All right, so welcome. Thank you guys so much for joining us today on this beautiful afternoon. So we're happy that you're here with us and glad to bring part 2 of our kind of legally protect your future with Bryana Crossbean. So today she's going to be talking more about long-term care planning essentials. And so my name is Caitlin Graves. I am one of the social workers in Northwest Medical Specialties, and I'm also a member of the Cancer Support Community. And so like at all of our presentations, I'd just like to talk just briefly about our partnership with Cancer Support Community. Cancer Support Community is one of the largest professionally led nonprofit networks of cancer support worldwide, so that no one faces cancer alone. And basically with our partnership, we're able to bring educational workshops like this, workshops with our providers in the community, support groups, social events, and more resources. So we're happy to be partnered with them, and we're so glad to bring you guys information that we hope is helpful to you. Just a little housekeeping. So we will take questions at the end, but if you have any questions that come up, definitely feel free to put them in the chat box. Bryana will be taking those questions at the end, and she will be able to see those there, or we'll make sure she gets those answered. And then best view is speaker view. So in the right, top right of your screen, you can usually change the view. A speaker view is best, so you can see the speaker throughout in the presentation. And I think that's kind of the bulk of my introduction. I'm going to pass it over to Eunice, and she's going to introduce Bryana for us.
Thank you, Caitlin. I'm very excited to present our speaker tonight, Attorney Bryana Crossbean, for graciously accepting to present for us tonight. The first presentation was on estate planning, probate, and guardianship, and is located on our Northwest Medical Specialties YouTube page. So please check it out if you missed it. I will also be uploading this recording within the next couple of days. So feel free to share with anybody and let them know. Bryana's primary practice areas are estate planning, long-term care planning, elder law, and probate. She also does small business formation and real estate contracts. She has been a practicing attorney in Washington since 2013 and has had her own practice since 2014. She centers her practice around helping clients plan for the future by anticipating problems before they occur. Bryana currently lives in Bonnie Lake with her husband, children, and pets. She enjoys gardening, hiking, and spending time with family. Please join me in welcoming Bryana.
Thank you so much for that introduction. Good evening, everybody. Thank you so much for attending today. As Eunice said, my name is Bryana Crossbean. I'm an attorney. And just to give you a little bit of a overview of kind of who I am, I've been in practice for about 8 years, and Eunice already talked about my primary practice areas. And I am, my primary office is in Puyallup, kind of down near South Hill Mall and Costco. And then I also have a satellite office over in Gig Harbor that I'm at once a week. And this is being recorded, but I have also provided my slides to Eunice today, so she can get them out to anyone who is interested. So before we really dive into long-term care, I just want to do a brief review of what my last presentation was. So last time I presented about estate planning and probate. So as a reminder, the primary documents that everybody needs, no matter their situation, is a will, durable power of attorney, healthcare directive. And if you don't get anything else, get a durable power of attorney, because that allows you to appoint someone to make medical and financial decisions for you when you're unable to. All right, so let's get into the meat of long-term care and how I'm going to kind of structure this presentation today. I'm going to give you a brief overview of kind of what long-term care is, just some basic facts and figures. I'm going to talk about how to prevent the need for long-term care with fall prevention, then doing a deep dive into Medicaid, finally going on to aid in attendance, and then at the end, talking about some planning methods. This is going to be kind of dense, especially in terms of the rules. Don't feel bad if you are having trouble following. That's why this is being recorded, and that's why you will have access to the PowerPoint slides. So what is long-term care? Long-term care is a really broad category of things. So it really centers around needing assistance with activities of daily living. So those are things like bathing, using the restroom, walking, feeding yourself, medication management, things like that. And there's a broad range of kind of what long-term care looks like. It can be anything from somebody coming in once or twice a week to help you shower, all the way to full-blown skilled nursing care, which is 24 hours. So really, really broad range. For the most part, people kind of start small, especially if you develop dementia, and then progress to needing 24-hour care. 70% of all adults will need some form of long-term care during their lifetime. So that, what that tells me is that long-term care is a probability rather than a possibility. It's really important to be sure that you're at least educating yourself about what to do if you do need long-term care. The average monthly cost, and I'm talking in the Pierce County area, you're looking at around $6,000 per month. So per month. It ranges $1,500 to $15,000 per month. So part of the reason it's so important to educate yourself about long-term care is it is really, really expensive and can really cut through and deplete your savings quite quickly. So most facilities have what's called a private pay requirement. And that means that you need to pay out of pocket, typically 1 to 4 years. The average is two to 3 years. And what that means is that some facilities accept Medicaid, some don't. The facilities that do accept Medicaid are going to make you pay out of pocket or through long-term care insurance or other method 1 to 4 years before they'll accept Medicaid. So that's something that is very important to know if you do need to go into a facility, whether they have a private pay requirement. And many times it's also going to, an elder law attorney, for instance, to look at your finances and talk about Medicaid and just see what sorts of options you may have. So there's a few different ways to pay for long-term care. The most obvious one is private pay. That means paying out of your pocket. Long-term care insurance can be a good option to help pay for long-term care. And I stress the word help because it typically doesn't take you all the way through unless you have a very, very old policy. I can count on one hand the number of times I've seen I've seen someone be able to pay for all of their care with a long-term care policy. Most of them end up having a cap of about, or I think it's a lifetime maximum. I'm not an insurance producer, so I defer to the experts on that, but they'll have a lifetime maximum of about $350,000. That's what I see on average. And that's great to get most people through the private pay requirement. So the clients I have who have long-term care insurance are typically in a better position to overcome the private pay requirement than people who aren't. And I'm going to just run a quick calculation. So let's just say we're doing $6,000 a month, so times 12, that is $72,000 a year. So just kind of sit with how much that is per year. Right. Another way to pay for it is through Medicaid / COPES, which I'll be talking about in a few minutes. That when you run out of money, that's kind of the main way to pay. There, you can also pay through with it for it. And I apologize, I have a 6-month-old daughter at home, and I have not had enough caffeine today, so I'll get the words out. They might just be a little bit awkward. So VA benefits are another way to pay for long-term care, and we'll talk about that as well. Another way to pay for long-term care that's not on here is through reverse mortgages. So I don't have a set slide for that, but I'll just give a brief overview of kind of what that is and how that can be useful. So with reverse mortgage, it's where you're essentially tapping into the equity in your home to pay for long-term care. There's a lot of different rules surrounding that. If anybody is interested, I am very happy to give a referral to somebody who does do reverse mortgages and knows all of the ins and outs of that. But reverse mortgage can actually be a really good option for people who absolutely want to stay at home and want to use the money from their home to pay for somebody to come in to pay for or to provide care for them. All right, so let's talk about fall prevention. Now, you might not think about this in terms of long-term care, but I think it's actually a really important component of planning. So older adults are at fairly high risk of falling. And the big component and the big reason about why fall prevention is a good thing to talk about in terms of long-term care is that staying safe at home can actually delay your need for long-term care. There's a number of wonderful ways to reduce your risk of falls. You can do it through grab bars, like a toilet or shower, having clear walkways, wheelchair ramps, shower seats, any number of things like that. And this is a screenshot from a pamphlet that the CDC puts out. So preventing falls is actually a public health issue because it can be so dangerous for people. So this is a great practical kind of list of ways you can stay safe at home. So with preventing falls, unfortunately, I've seen this many times where somebody will have one fall and maybe they'll fall and break their hip, and it starts this horrible cascade of health issues, and they wind up in a long-term care facility, which most people want to avoid as long as possible. So it is so important to stay safe at home. Okay, really important. I talk with a lot of families, and sometimes kids are bringing their parents in because they want to learn more about long-term care, and I'll talk about fall prevention with them, and very often the kid kind of looks knowingly at mom and dad looks a little sheepish, and I ask, oh, do you fall? And very often the answer is yes. So you want to be the one who's making the decision for yourself about when and if you need to go into long-term care. You don't want it to be made for you because you slipped on a rug in your home, or you tripped over your cat, or something like that. I cannot emphasize enough how important it is to prevent falls. So now that I'm off of my soapbox for that, let's talk about Medicare versus Medicaid. They sound very similar, and a lot of people do get them confused. So Medicare is the traditional type health insurance for adults age 65 and older, and also for some people who are younger. They can get qualified for Medicare with certain health conditions. Now, Medicare should not be considered a way to pay for long-term care. It covers very, very little long-term care. Depending on the plan that you have, it'll cover 30 to 90 days max. That's it. I've had so many people say to me, oh, I don't need to plan for long-term care because Medicare is going to cover it. Medicare doesn't cover it. Medicare is wonderful with paying for hospitalization and hospice, rehab, things like that. They are not good for paying for long-term care. So there's a very important distinction when you are trying to get Medicare benefits after being in a hospital. It depends whether you are classified as being an inpatient or under observation. That distinction is key because it means that if you are classified as inpatient, Medicare will cover any rehabilitation that you need. So, falling and breaking your hip, you need to get physical therapy, occupational therapy in kind of a temporary nursing home setting. Medicare will cover it if you are classified as an inpatient. If you're classified merely as being in under observation, Medicare will not pay for that rehab. Rehab in general is very, very expensive, and it's more expensive than your average long-term care because it is closer to nursing home level care, and you're looking at closer to $15,000 per month. So it's very important if you're in the hospital, being sure that you are fighting tooth and nail to be sure that you are classified as inpatient, or also if you have a family member who is in there, being sure that they are being classified as inpatient. Then talking about Medicaid a little bit. There's two main types of Medicaid, and it's going to be the second type that we focus on. The first type is traditional insurance for low-income individuals under age 65. So it's essentially, no, that's not quite right. It looks like Medicare, but it's for people under age 65, and you have to be low income. The second type is what we will be focusing on today, and that pays for nursing home and other long-term care if, and a big if, the applicant meets medical and strict financial requirements. So let's talk about really dive into Medicaid. There's two types of Medicaid that pays for long-term care. Luckily, they are under the same application. So one just basically has higher medical acuity, so you're needing more help with things than the other. Traditional Medicaid is for nursing home care. Washington has this other program called COPES, and that stands for Community Options Program Entry System. This is what most people end up being on, at least initially, and this is to help with assistance of activities of daily living. So as a reminder, activities of daily living, bathing, toileting, ambulation, unfortunately, something that is not included as an activity of daily living under Medicaid or VA for that matter is medication management. And this is something myself and a lot of other elder law attorneys are upset about, because basically we all think medication management should be considered an activity of daily living that Medicaid and COPES will help pay for. And my understanding of the reasoning is that there are pharmacies who do a great job, but they can kind of pre-package an individual's medication for morning, noon, and night, which can be great, and that can be helpful to keep people from getting their medications confused. However, I work with a lot of people and their families where dementia is an issue. And so you're not even going to remember that you have any medication to take, and you're going to need that queuing. But COPES and Medicaid will not consider medication management as an activity of daily living. So just realize that that is an issue. Hopefully that'll change over time, but this is what we have right now. So in order to qualify for Medicaid, you must meet medical and financial eligibility requirements. Medical requirements, less of an issue. You basically just need the type of care that a long-term care facility provides. There are, however, two components of financial eligibility, and financial eligibility is always the hardest to work with and to get qualified for. So like I said, with medical eligibility, you just need medical care that long-term care facilities provide. For financial eligibility, you have to meet resource and income requirements. I'm actually going to do income requirements first. It needs to be less than what's called Medicaid rate for your care, plus your regular monthly expenses. The Medicaid rate does differ depending on your level of care, and that'll how much Medicaid is willing to pay per month will get determined when during the application process. Now, the average Medicaid daily rate is $346, and I don't know the maximum for that. But for most people, they're able to fairly easily meet that income requirement unless they're not needing a lot of care. The definition on here that I have is kind of the proper definition, but another way to think about it is that you need to be spending more on your care than you are getting per month. So you're already starting to need to dip into IRAs, savings, investment accounts, things like that. That's a good way to kind of realize that, oh, maybe Medicaid is going to be in my future at some point. Resource requirements. This is always the worst part of it. So for the applicant, they can have no more than $2,000 in non-exempt resources. We'll talk about exempt resources in a minute. And if you are married, it limits how much money your spouse can have as well. So the well spouse, that means that the spouse that doesn't need Medicaid can keep $58,075 in resources, in non-exempt resources. They can have unlimited income, and we'll talk about why this is important in a couple minutes. So just keep in mind, you really, really have to be out of money to qualify for Medicaid. So exempt resources. So this means resources not counted in the $2,000 resource limit or the $58,000 resource limit. Your home has to be worth less than $603,000. More specifically, it's the equity in your home has to be less than $603,000, and this goes up a little bit each year. Last year, I think it was about 592,000. That's right. But with equity, why I'm making that distinction is that if, let's say, you have a home that is worth $700,000, but you have a $100,000 mortgage on it, technically your home equity is $603,000, and that is exempt. Now, if you're kind of at that level, that's going to get tricky, because at some point, as you pay off the mortgage, your equity is going to increase and your home may no longer be exempt. So just kind of splitting hairs there, but something to think about in terms of that. Other exempt resources are household goods and personal effects, and also durable medical equipment. So pretty much anything that any personal items that you can hold and touch. You can have one car of unlimited value, and it has to be used for transportation. So technically, and I have not seen anyone do this, but it would be allowable under the rules, you could have a $200,000 Porsche, for instance, and that would still be exempt as long as you are using it for transportation. You can have a life insurance policy, but the cash surrender value of that has to be less than $1,500. I remember a presentation I gave in front of financial planners a few years ago, and they started laughing when I gave that rule, because those are pretty much unheard of. So for the most part, life insurance policies are non-exempt, and these are tricky. When I'm meeting with a client and we're talking about Medicaid, I'm going through whether they're eligible or not, and I ask them the kinds of assets they have. They don't realize that life insurance, for the most part, is an asset, because at least with term life, I know whole life is a little bit different, but at least with most term life policies, you can actually sell that for value, and Medicaid will make you sell it. If you can sell it and the cash surrender value is less than or is more than $1,500, you have to sell it, and that can be kind of tough. Most burial plots and prepaid funeral and burial plans are considered exempt resources. And you can have a burial fund of $1,500 or less per person. One thing, and I probably should have made this a separate slide that I'm kind of thinking about, that I want to go back to, kind of with the fall prevention and keeping yourself out of long-term care, is something called caregiver burnout. I suspect at least some of you are familiar with this. I see it with a lot of married couples, and caregiver burnout is a big issue. So let's say, and this is normally the way I see it, is the wife will be caring for the husband with dementia, for instance, and normally the husband is bigger than her, and she is helping move him, get him in and out of bed, sometimes get him in and out of the tub, and the caregiver spouse can, they can definitely have burnout, because they're on the go, they're on for 24 hours a day, and sometimes they can fall too. A personal story of mine, kind of a family member of my husband's was actually doing this exact thing, where she was this tiny woman, about 5'1", and she was caring for her husband, who was over 6 foot and a bit on the heavy side. And she was trying to help him get out of the tub and wasn't able to, and she fell and actually had to go into the hospital because she broke her arm. So just realize that caregivers need to care for themselves as well. So it's really important to be reaching out to not only family members, but also resources, community resources and resources through your medical providers to get some of that assistance. All right. So talking about Medicaid, kind of going back into that again, one of the hardest things about Medicaid is that there is a 5-year look back. Any gifting within 5 years prior to applying can result in ineligibility or delayed eligibility. For example, a gift of $100,000 can result in 289 days of ineligibility. So how that calculation is being made is I was taking the Medicaid divisor, which is the average daily rate. This year it's 346. Last year I want to say it was 317, something like that. So you divide the amount of the gift by Medicaid's average daily rate, and you get the number of days of ineligibility. And that means the number of days that you have to wait from when you were otherwise eligible. That means that you meet all other financial eligibility requirements. So you're down to $2,000 in the bank, and let's say you're trying to get on Medicaid faster, and you gifted your kids $100,000. You can't do that. You can't do that. There are very limited exceptions to this. The two exceptions are giving money or property to a spouse or disabled child. That does not trigger that gifting penalty, and also gifting to a caregiver child. Now, the caregiver child gift exemption is very, very difficult to do, because you need to do that at the same time that you are eligible for Medicaid. And this is a very, very key thing. And Medicaid has really, really cracked down on pretty much any major loopholes to do asset transfers within 5 years of needing to apply. So Medicaid will pay for some home care. It will not pay for very much. And that is by design. I've spoken with more than one caseworker, and they've been very frank with me that they intentionally do not pay for much home care. So if you are needing to apply for Medicaid, if you're going to be running out of money, you need to be looking at a facility. You can get some home care initially, and that can work out fine. But when you're starting to need a lot of home care, then you need to go into a facility. This was a case from a few years ago. My client's mother absolutely wanted to stay in her home, did not want to leave under any circumstances, but she needed 24-hour care. And she'd been able to pay for it for a couple years, but she was paying $12,000 a month in home care. So 24-hour home care gets very, very expensive. And she wanted to apply for COPE. So we did the application. They only awarded her 36 hours per week in care, in home care. And so my client was forced to take her mother out of the home that she had really, really wanted to stay in, and move into the first long-term care facility that she could find that would accept Medicaid immediately. The long-term care facilities that accept Medicaid immediately, they're not necessarily few and far between, but they are difficult to get into. And that's because there is such a huge demand for Medicaid and for long-term care services. So very often they have a wait list, and I've seen that wait list, I don't know, 9, 12 months, sometimes for needing for Medicaid immediately places. So it's really, really important to start this planning early and realize that sometimes, as much as you want to, you just cannot permanently stay in your home unless you have a lot of money. If you have a lot of money, you don't even need to worry about it. But most people really do need to at least think about this. Talked about that. So let's talk about estate recovery now. So this is another tricky thing with estate recovery, or with Medicaid. Washington State is allowed to reimburse itself for paying for long-term care and other care, specifically from estates of Medicaid and COPS recipients. So generally, any long-term care paid by Medicaid is subject to recovery for recipients ages 55 and older. So that means that very often when somebody passes away and they're on Medicaid, the major asset that they have is their home. So Medicaid will place a lien on the home, which is required to be paid off in order for it to basically be sold, or at the same time it's being sold after somebody passes away, then Medicaid gets to get recouped for their costs. Most assets are subject to recovery. So for the recipient, it is all separate property. So that means all property that's just in their name, and then 1/2 of the community property. So 1/2 of any property owned by them and their spouse together. For the spouse, no portion of the separate property is able to be recovered. So let's say that the surviving spouse had a bank account that had $20,000 in it, and their spouse who was on Medicaid needed or passed away. So the deceased spouse's assets can be gone after, but that $20,000 bank account of the surviving spouse cannot be gone after. Like I said, the recipient's half of the community property can be gone after. So if you one spouse passes away and they owned a house together, then Medicaid will place a lien on the recipient's half of the house, and they are not allowed to make a claim for any higher amount than they had paid out. So if they only paid out $5,000, then the lien would only be for $5,000. Now, in the case of a home owned by a married couple, recovery is only allowed after both spouses have passed away. So the surviving spouse can continue living in the home until they pass away. All right, let's talk about another option to help pay for long-term care, which is aid and attendance. Now, this is very specific to veterans and their spouses. It's a stipend to assist veterans and their spouses in paying for long-term care. Current numbers for this: married vets can get $2,295 per month. A single vet can get $1,936 per month. The surviving spouse of a veteran, assuming that they did not divorce them or that they have not remarried, can get $1,244 per month. Now, this stipend is decreased by the percent the veteran was disabled. So I've seen this for a number of Korean War vets for some reason, that they'll have a 10% disability rating for hearing loss. So, and that's hearing loss that is due to their military service. So that amount per month is decreased by 10%, or if they were 20% disabled. One thing that I do want to bring up, and this is slightly different than aid in attendance, but I'm seeing it more and more, is that there's a lot of Vietnam vets who are starting to need long-term care. And I'm sure most of you have heard of Agent Orange. Now, you know, Agent Orange, the pesticide, or it wasn't pesticide, herbicide, I guess, that was sprayed during the war. That is really, really nasty. And there new diseases that have a direct link to that are continuously being discovered. So why that's important is that you can apply for, and I'm blanking on the term, but I guess it's a type of disability benefit that does not apply, that doesn't have anything to do with any sort of long-term care that you may need, and doesn't depend on how much money you have. So if you or your spouse were serving in Vietnam and developed kind of a funky cancer, there's any number of different ones. If anyone is interested, I can send you a link to all the different illnesses that have been attributable to Agent Orange exposure. And if that does apply to you or a family member, you're better off to apply for that benefit. It's easier to apply for. Sometimes you get more money, and also you're not having to spend down a lot of your assets to qualify for that. So, side note, coming back to aid in attendance, eligibility for aid in attendance, kind of similar to Medicaid. You need at least assistance with at least 2 activities of daily living. The veteran themselves has to have served at least 1 day during wartime and not have been dishonorably discharged. And then for the surviving spouse, they cannot have gotten remarried, and they also cannot have divorced the veteran. Now, the wartime periods that is considered: World War II. I have gotten a few of those on occasion. It's just the surviving spouse nowadays, but World War II, Korea, so 1950 to 1955. Vietnam is a little bit weird. So if you served actually in Vietnam, so in country or in the waters surrounding Vietnam, the wartime period is 1961 to 1975. For everybody else, it is 1964 to 1975. And Persian Gulf, that includes Iraq, Afghanistan, War on Terror. Last I checked, there's still not an end date officially by VA standards to that war. So 1990 to today, essentially, and ongoing. I want to make a distinction about serving during wartime, because this causes confusion sometimes. You don't need to actually have been in combat. If you were stationed at, let's say you were stationed at JBLM for 1950 through 1953. You never set foot in Korea, never left the US or anything, but technically you were active duty, that qualifies. Okay, that's something that people think sometimes that, oh, I'm not eligible for this because I didn't hold a gun in a foreign country. You don't actually need to have gone overseas. You just need to have been classified as active duty. And so how you're classified as active duty is through your DD 214. And I don't think I had a slide on this, but the DD 214 is your discharge papers. And you can get a copy of those through the VA for no charge. And sorry, I'm actually just going to take notes because I realize I'm giving you guys a number of resources and I want to be sure that I'm remembering. And then let's see, Vietnam. Okay. So for eligibility requirements for aid and attendance, you can have a maximum of $129,094. What's a little confusing about this is that this includes yearly income. So aid and attendance is great for people who are low income. And this, the 129,000 applies to both you and your spouse combined. So VA doesn't make the distinction between married and single like Medicaid does. So sometimes it can be difficult to get qualified for aid and attendance when you have higher income. So let's say you, an easy number for this is, let's say you and your spouse take home $100,000 each year in income. So that means that you can have $29,000 left in non-exempt resources. And the exempt resources are the same for Medicaid, except that there is not a limit to home value. So theoretically, you could have $1 million home and still get qualified. But sometimes it's really not worth it to apply for aid and attendance because you'll end up needing to apply for Medicaid. So let's give that example again of a married couple who has $100,000 and needs one of the spouses needs long-term care. So the well spouse can only have, I guess, minus $2,000, so it would be $27,000. Now, it's not going to be worth it to apply for aid and attendance, and I'll tell you why. So when you apply or when you get aid and attendance, the money that you use, that you get from that has to go towards your long-term care. And so it's great if you're trying to overcome a private pay requirement, or maybe you need just a little bit of assistance at home. So you can spend your money on getting home care. Now, if you're going to end up needing Medicaid anyways, it's not worth applying for aid and attendance because all of the money that you are receiving is just going to go towards that long-term care facility. And applying for aid and attendance is tough. I really recommend getting assistance with applying for this. The VA rules are really complicated, and what's even more complicated is their forms, which change all the time. A couple of years ago, I was doing VA applications. I'm not anymore because you can't get, as an attorney, you can't get compensated for those, but I've done enough of them so that I'm kind of familiar with the forms enough to know that if I didn't have a program that I purchased at the time to help me fill out the forms for my clients, I would be struggling with it. And this is, I do this kind of thing for a living. And if I'm struggling with it, I can only imagine how much trouble somebody would have who is not familiar with this. There's lots of different forms to fill out. They are confusing, and VA is very, very picky about the language that you have to include. So I recommend going to a veteran service organization to help you apply for this. And as I said, you can't, the person who's assisting with the application cannot be compensated. This is key. There have been some, unfortunately, it's financial planners, not too much anymore, but there have been some financial planners in the past who were charging people to do the aid and attendance application. That is illegal. They're not allowed to do that. Go to a veteran service organization. They can help you with that. The main one that I know of in the Pierce County area, there is a VFW in Fife that I've had some clients go to, and they have had good luck with them. So, with a fairly recent rule change for aid and attendance is that there is now a penalty for gifting within 3 years of the application. There used to not be any gifting penalties, but in 2018 that changed. So realize that there is a penalty for gifting within 3 years of the application. All right, so now that I have thrown you a ton of rules, let's talk about how to actually plan for this. So the traditional way to end up getting qualified for Medicaid is the spend down. So common ways are to, and spend down means what it sounds like. So spending your money. So you can spend your money however you choose, with the exception of gifting, but you can spend it on your health care. That's the most common way. So spending it on, a 2-year private pay. You can also do home improvements, making it more handicap accessible, remodeling, really anything under the sun, as long as you are doing it for your home. You can upgrade a car. If you are wheelchair bound, you can, purchase one of those vans that is that has a, what is that called? Kind of the wheelchair lift on it. That's absolutely acceptable. You can purchase durable medical equipment. So, maybe a snazzy electronic wheelchair. And then another really common thing to spend money on is purchasing a prepaid irrevocable funeral plan. So the kinds of funeral plans that are considered an exempt resource under Medicaid, they have to be irrevocable. So there's no way to cash them in and get money back out. Most funeral homes are actually very well aware of this, and it's kind of a marketing technique for them. So most of them are pretty familiar with what the funeral plan needs to look like to qualify for Medicaid. Another way to help qualify is spousal transfers. This is a very, very effective way of helping spend down. So we're taking advantage of the rule for unlimited transfers being allowed between spouses. And the way you capitalize on this is that you can transfer community property, so and most of the applicants' separate property, to the well spouse, which includes the home, but obviously keeping out $2,000. So let's say that, and this assumes either both spouses have good capacity or they have durable powers of attorney in place, so we can easily do this. But let's say husband and wife own a home together. They don't have a mortgage on it. Mortgage makes things trickier. But if they don't have a mortgage on it and the wife needs Medicaid, then she can essentially sign over her interest in the home to her husband. And then her husband can continue to live in the home, and assuming he never needs Medicaid, then Medicaid can't place a lien on that home after he passes away, because it's not in her name anymore. And because money and property can be transferred between spouses, then you're not triggering that gifting penalty. So some benefits: easier qualification for Medicaid, can avoid the Medicaid lien on home. The main risk is that the well spouse may end up needing to go on Medicaid in the future, so it might not be fully possible to avoid the lien with that. Right. Another planning technique that I am a big fan of is something called a Medicaid qualifying annuity. So I don't know if you remember from a little bit ago, I mentioned that the well spouse can have unlimited income. This is an important component of Medicaid eligibility and planning. So you can't have $100,000 IRA and still get qualified, but you can convert that IRA into a special Medicaid qualifying annuity. So it's converting the IRA or other assets into a stream of income. So instead of having that $100,000 IRA, maybe the well spouse is getting $3,000 additional per month, for instance. So it's not quite the same thing, but it's better than having to spend down that $100,000 annuity. So the requirements for this is that DSHS, and that's who administers Medicaid in Washington, has to be named as the remainder beneficiary. So that means that if the spouse who needs Medicaid passes away and there is still money left in the annuity, then DSHS gets first dibs and can place a Medicaid lien on that. Medicaid qualifying annuities, and the kind of annuity is for any of you financial planners out there, is a single premium immediate annuity. So it's a SPIA. It has to be irrevocable, and it has to be a term of 5 years or the life expectancy, and I think it's whichever is shorter. So most of my clients end up doing the 5-year term. Now, from a financial planning perspective, this is not a great thing to have, because it really doesn't earn you anything in the same way that an IRA does. So it's a way of preserving your money rather than making money. For when I'm helping out a client qualify, I always recommend, if they are going to need to do a Medicaid qualifying annuity, that they wait until kind of roughly at the same time or just before they apply for Medicaid. And this is because you don't really earn any interest on it. So keep using the investment vehicles that you already have, and wait until kind of the last minute to convert those assets into that SPIA. Now, it's an effective way to qualify for Medicaid, but still receiving the benefit of the assets and preventing the well spouse from being impoverished. Okay, now a planning technique that you can do, this is tricky though, and I do them sometimes, but not a lot, mainly because for most people, they're not a great fit. But it is an option. So it's a type of irrevocable trust. And the purpose of it is to more easily transition onto Medicaid while leaving a legacy to your heirs. So basically allowing your heirs to, or guaranteeing them an inheritance. Now, the trustor, so that's the person creating the trust and ultimately the Medicaid recipient, they have to be able to private pay for at least 5 years to overcome the Medicaid look back. Because when you do this trust, and most people end up putting their home in it, and then, you know, at that point, the home can be sold and then money can go to heirs in the future. But most commonly what's placed in there is a home. But it's a gift. So because it's a gift, it does trigger that Medicaid look back period. And remember how I said that that penalty period starts when you are otherwise eligible, as opposed to the date of the gift. And this can make a big difference. So the way the rule used to be is, and I'm going to just make the numbers very easy. Let's say your home was worth $100,000, and we still have the same gifting divisors. So let's say you gifted $100,000 home, and you placed it into this trust. You can't then qualify for Medicaid, you know, a year from then. If you remember, the penalty period was 289 days. So the penalty period starts when you're down to $2,000 in the bank, and you have to figure out a way to be able to afford your care for that 289 days or whatever it ends up being. So that's why if you're going to do this trust, and I've seen it work well for people, so I don't want you to think that it can't be done. It's just for a lot of people, it's not the best option, and it is inherently risky. So you have to be able to pay for your care for 5 years. That's really the only way that this trust can be effective, is if you have the amount of assets to pay for care for at least 5 years. You have to have a solid trusting relationship with your family. So very, very often the trustee, so that's the person managing the trust, is a family member. Usually it's an adult child. And the adult child is typically the trustee and what's called the lifetime beneficiary. So there's a lifetime beneficiary and there's a death beneficiary. If for some reason you run out of money before 5 years is up, you know, let's say you thought you were only going to be spending $3,000 a month, and you end up having to spend $10,000 a month, and you run out of money sooner, then you would have to ask that adult child to go in and pull money out of that trust to help you. And so they would be paying the facility directly as opposed to you. If you get any of that money from the trust whatsoever at any point, Medicaid will treat it like an available resource, and they which makes you ineligible. So all of a sudden, all that money or the property that was in the trust that you were trying to protect is now an available resource. So this has to be done in a very specific way, and do not try to even remotely think about doing this on your own. You have to have a well-trained elder law attorney do this for you, because it's not suitable for everybody. And I have had to correct a number of different trusts for very well-meaning attorneys who tried to help their clients, but they didn't have that knowledge base in order to be able to do it effectively. And keep in mind that a revocable living trust does not protect your assets at all. It's great for avoiding probate, but it does not protect your assets from the Medicaid viewpoint, because it's considered a see-through entity, which means that any asset that's in there is considered an available resource. So a revocable living trust is not an effective way to protect your assets for Medicaid. You have to treat this trust like a safe. So ideally, you never want to access it. This is great for people who, let's say, have a piece of real estate, and maybe it's been in their family for a really long time. And actually, I did one of these pretty recently. It was a farmstead in the Midwest that has been in this person's family for generations. And she just about burst into tears when I told her if she didn't do anything about it, then Medicaid was going to force her to sell the property. So and she had plenty of resources, good relationship with her kids. So in that kind of situation, that irrevocable trust can be a great option. Okay, so as I kind of alluded to, the trustor, so the person creating the trust and who is ultimately applying for Medicaid, cannot be the beneficiary. Any formal connection to that, where any money is going from the trust directly to the Medicaid recipient, is considered an available resource. So few risks of this. If the trustor runs out of money before 5 years, so the family members have to be willing to use the money for the trustor's benefit. And that means paying the facility directly and not directly giving it to the trustor. Another big risk is family disputes. When I was first starting to practice, I was sharing office space with another attorney who had actually done one of these trusts, but then the family just completely fell apart. And I wasn't directly affiliated with that attorney, so I ended up having to come in and essentially help unwind this trust because the kids and the parents no longer got along. So there ended up having to be thousands of dollars spent on legal action to unwind the trust. And I think that's my last slide. Yeah. Okay. So I am going to stop sharing, and I know I have thrown a ton of information at you, and I would like to open it up to questions. And